Will Jet Airways fly again? In this slideshow, we will look at the Jet Airways insolvency resolution process. On 20th June 2019, three insolvency and bankruptcy court petitions came up before the Mumbai bench of the NCLT against Jet Airways Limited. These were CP 2205 IB of 2019, CP 1968 IB of 2019, and CP 1938 IB of 2019. These were under Section 7 and Section 9 of the Insolvency and Bankruptcy Code 2016. Now, CP 2205 IB of 2019. In this matter, State Bank of India, a financial creditor of Jet Airways, hold the company to the NCLT under Section 7 of the IBC for initiation of IBC proceedings. In CP 1968 of 2019, Gagar Enterprises Private Limited, an operational creditor of Jet Airways, went to the NCLT under Section 9 for initiation of IBC proceedings against Jet Airways. In CP 1938 of 2019, Shaman Wheels Private Limited, again an operational creditor of Jet Airways Limited, approached the NCLT for initiation of IBC proceedings against Jet Airways. Now, on 20th June 2019, the Mumbai bench of the NCLT admitted Jet Airways Limited into the corporate insolvency resolution process. Now, during the process, the operational creditors express their support and consent to CP 2205 of 2019 being admitted under Section 7 of the IBC. Consequently, CP 1968 of 2019 and CP 1938 of 2019, brought on by the operational creditors under Section 9 of the IBC, became infructuous and were therefore dismissed. Of course, liberty was given to the petitioners of both these petitions, CP 1968 of 2019 and CP 1938 of 2019, to file their claim before the resolution professional appointed in CP 2205 of 2019. So of these three petitions, CP 2205 of 2019 was admitted by the NCLT for initiation of corporate insolvency resolution process against Jet Airways Limited. Now, the total amount of default by the corporate debtor Jet Airways vis-a-vis this particular creditor, financial creditor, State Bank of India, was to the tune of 976.6 crore. Now, this amount was in default as on 15/5/2019. 30 days later on, that is 15/6/2019, 15 June 2019 was taken as the date of crystallization of this default. Now, on being admitted into the CIRP proceedings, the next step is declaration of moratorium under Section 14 of the IBC. Consequently, the following directions were also issued. Number 1, this bench prohibits, number A, the institution of suits or continuation of pending suits or proceedings against the corporate debtor, including execution of any judgment, decree or order of in any court of law, tribunal, arbitration panel, or other authority. This court prohibits the transferring, encumbering, alienating, or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest therein. 1C. This court prohibits any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of its property, including any action under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interests Act 2002. 1D. This court prohibits the recovery of any property by an owner or lessor where such property is occupied by or in possession of the corporate debtor, in this case Jet Airways. 2. That the supply of essential goods and services to the corporate debtor, if continuing, shall not be terminated or suspended or interrupted during the moratorium period. 3. That the provisions of subsection 1 of section 14 of the Insolvency and Bankruptcy Code shall not apply to such transactions as may be notified by the central government in consultation with the financial service regulator. Now, section 14.1 talks about the moratorium as we have seen previously. 4. That the order of moratorium shall have effect, look at the from date, from the date of this order till the completion of the corporate insolvency resolution process, or from the date of this order until the bench approves the resolution plan under subsection 1 of section 31 of the Insolvency and Bankruptcy Code, or passes an order for liquidation of the corporate debtor under section 33 of the Insolvency and Bankruptcy Code, whichever case may be. 5. That the public announcement of the corporate insolvency resolution process shall be made immediately as specified under section 13 of the Insolvency and Bankruptcy Code. Is the public announcement under section 13, where you have the name of the corporate debtor, the date of incorporation, authority under which the corporate debtor is incorporated or registered, that is the Ministry of Company Affairs, ROC, Mumbai, its identity number, address, insolvency commencement date, estimated date of closure of insolvency resolution process, which was taken as 16 December 2019, that's 180 days. The name of the insolvency resolution professional, his address, and other details as required. 6. This dealt with the appointment of the interim resolution professional. In this case, it was Mr. Ashish Chawacharya. He was appointed as interim resolution professional to carry out the functions as mentioned under the Insolvency and Bankruptcy Code, and the fee payable to him shall comply with the regulations issued by the board. Now, the insolvency resolution professional was directed to submit his fortnightly progress report to expedite the corporate insolvency resolution process of the corporate debtor without delay of even a single day. Considering the matter being of national importance and the corporate debtor has been one of the largest private sector airlines, the huge number of workforce of more than 20,000 employees, large number of international flights, and domestic flights. Having regard to these considerations, the NCLT directed the resolution professional to make every possible effort to complete the corporate insolvency process at the earliest possible time. It was also pointed out that the IBC provision provides for 180 days of completion of the CIRP, but every effort should be made by the resolution professional and the members of the COC to expedite the matter and try to finalize the resolution process on the fast track mode, and they should not preferably wait for the completion of the statutory period, which is either 180 days or 270 days under the IBC. Now, the Noor Holland District Court, Netherlands. Now, prior to the admission of CP 2205 of 2019 by the Mumbai bench of the NCLT, Jet Airways Limited was taken to the Noord Holland District Court in the Netherlands, and an order of bankruptcy was passed against it on 21st of May 2019. Now, on 20th of June 2019, during the NCLT proceedings, Mr. R. Mulder, that's the administrator appointed by the Noor Holland District Court in the Netherlands, made an intervening application to stay the proceedings before the NCLT in view of the orders already passed by the court in Amsterdam. Now, the Mumbai bench of the NCLT rejected his application, saying that, among other things, there is no provision and mechanism in the IBC to recognize the judgment of an insolvency court of any foreign nation, and also that the matter was of national importance and the carrier's revival at the earliest by a viable resolution plan was very essential. It thus passed the following order, namely, the IRP is directed to proceed in the matter with immediate effect without being influenced by the order of the Noor Holland District Court, Netherlands, and file the progress report every fortnight. And then orders were passed to the registry to communicate this order to the financial professional, the corporate debtor, and the interim resolution professional, even by email or WhatsApp. Now fast forward to 20th December 2019. This is 6 months after Jet Airways was admitted into the corporate insolvency resolution process. Now, MA 3905 of 2019 in CP 2205 of 2019 was filed by the State Bank of India against. Now, MA 3905 was filed by the resolution professional under Section 12.2 of the IBC. Now, Section 12 of the IBC talks about the time limit for completion of insolvency resolution process. And 12.2 specifically states that the resolution professional shall file an application to the adjudicating authority to extend the period of corporate insolvency resolution process beyond 180 days if instructed to do so by a resolution passed at a meeting of the Committee of Creditors by a vote of 75% of the voting shares. Now, it was contended that the Committee of Creditors, in its 5th meeting held on the 19th of November 2019, passed a resolution for the extension of the corporate insolvency resolution process period by a further period of 90 days. So you had 180 days getting over in December, and now they're asking for 90 days. Now, the applicant, that is the resolution professional, also filed an additional affidavit on 13 December 2019, annexing the minutes of the 5th COC meeting. It appears from the minutes that the said meeting of the COC passed a resolution with a vote share of 90%. So this is way above the 75% required under the Act. And thus, MA 3905 of 2019 was allowed and disposed of. So now we have another 90 days coming into the resolution process. Now, fast forward to 18th March 2020. 270 days are done from the date of initiation of Jet Airways into the CIRP process. Now, I-918 of 2020 was filed in CP-IB 2205 of 2019 by the State Bank of India versus Jet Airways Limited. Now, this is an application filed by the resolution professionals seeking extension of 90 days for completion of the insolvency resolution process. Now, they have, over the 6 months period which is given by the Act, they have asked for 90 days, which takes it to 270 days. Now they want another 90 days for this process to take place. They gave their reasons, and the reasons were accepted by the bench. Namely, the bench is aware of the medical cum economic crisis created by the COVID-19 at the international level. They are also aware that there's disinvestment proposal of Air India in the offing, and it is learned that the time for submitting bids in respect of Air India disinvestment is extended by around 45 days. This is the most important. There is every possibility of resolution in this case, in view of the fact that valuable traffic rights and slots of the corporate debtor may be utilized, and the applicant is right in contending that for synergistic business reasons prevailing in this case has to be taken into account for granting extension. The judge also noted that they were aware that the aviation sector is also facing an extraordinary situation for which an extraordinary remedy was required. And thus, in this peculiar circumstance, if this bench declines the extension sought for, as an extension of 90 days has already been granted, the only option available to the corporate debtor is to go for liquidation, which may not be beneficial for any of its stakeholders, including the traveling public. Therefore, the application was allowed as prayed for by granting 90 days extension. And now the corporate insolvency resolution period will come to an end on 13th June 2020. So, we had 6 months getting over, 90 days getting over, and a further extension of 90 days being given, and thus the CIRP ending on 13th June 2020. Now fast forward to 30th of March 2020. During this time, we were in the midst of the global pandemic brought around by the coronavirus, and therefore the NCLT passed a comment. Now, the order dated 30th March 2020 of the NCLT read as follows. The period of lockdown ordered by the central government and the state government, including the period as may be extended either in whole or in part of the country, where the registered office of the corporate debtor may be located, shall be excluded for the purpose of counting of the period for the resolution process under Section 12 of the Insolvency and Bankruptcy Code 2016. In all cases where the corporate insolvency resolution process has been initiated and pending before any bench of the NCLT or an appeal before the appellate tribunal. So now, because of the pandemic, you had the process time limit increasing. Now, on 22nd of May 2020, the resolution professional, Mr. Ashish Shawacharya, sent a communique to the stock exchanges saying, because of the order of the NCLT, the period of 69 days between March 24, 2020, that is when the lockdown was imposed, and May 31st, 2020, when the lockdown is scheduled to be lifted, this period will be excluded for the purpose of computing the time period provided for completing the corporate insolvency resolution process of Jet Airways. Therefore, 21st August 2020 was the revised timeline for completion of the corporate insolvency resolution process of Jet Airways. Again, this was subject to any further extension of lockdown by the state government of Maharashtra or the central government, as the case may be. So now we have the lockdown, the CRP process ending on 21st August 2020. This communique further noted that the members of the COC of JET have, by way of resolution dated 12 May 2020, authorized the issuance of a fresh invitation for expressions of interest, with the deadline for submission of the expression of interest being 28th May 2020 and submission of resolution plans being 11 July 2020. This has been authorized in view of the prevailing circumstances arising on account of the COVID-19 pandemic and with the objective to maximize the chances of making a successful resolution of JET for the benefit of all stakeholders. Now, media reports as on the 4th of June 2020 stated that bids invited from 4 little-known suitors were shortlisted for Jet Airways. Now, it remains to be seen which of these 4 potential suitors succeeds in bailing out the troubled carrier and saving it from liquidation proceedings.